Good morning, friends. Today I am going to take the session on the anti-defection law, guys. So, guys, we people are aware of that this topic is in current affair in the recent days because of the increasing day by day defections. So, if you see what is defection is the either voluntary giving up the membership of the party. Okay, guys, that is the disobeying the party's directives of that leadership members is called as the defection, guys. So if you see what is defection is either the voluntary giving up on the membership of the party or disobeying the directives of the leadership of the party. What does disobeying mean? Disobeying means that if he is abstaining or voting against the whip, guys, clear, the directive is the whip. If he is voting against or abstaining means not voting, so not voting as per the whip, then it is called as defection, guys. Okay, clear? So why? Because this right now we are seeing the political crisis in the Karnataka, guys. Okay, and after that in the in the Madhya Pradesh, right now in the Rajasthan, guys. So for this purpose, this topic has been in the current affair for the past few days. Okay, guys. So why this is happening? Because, guys, this defection is applies only to the MLA or the MP who is in the present list, means who is in the present house. It does not imply to the previous people, guys. Okay, MLA or MP, the member of the legislative assembly or the member of parliament, guys. Okay, who are in the present condition, guys. Okay, present they are in the house. Okay, clear? So why this concept has done means in the year 1967, one of the MLA changed his party for thrice. One on, like that he changed for thrice, guys. So that's the reason this concept came in, guys. Does these provisions are having in the constitution at the original? No, guys. We have the disqualification of the legislature in our constituency, but about the anti-defection, but about the defection we are not having, guys. Guys, if you see the concept that we are having about the disqualification of the members, that is the legislature, we can see at the article number 102, that is the article number 102 for the parliament and the article number 191 for the legislative assembly, guys. If you see the article number 102 subclass 1, there clearly mentioned that. So it is the disqualification of the member of parliament for the following reasons, guys. First and foremost reason is if he is voluntarily give up his membership, guys. If he is voluntarily give up his membership. And second one, if you see, if he is an unsound mind, he is the mentally ill person. Okay, so that means like he is unable to do the processes of the parliament. Okay, unsound mind. And third one is the discharged insolvent. If he is the discharged insolvent means he is not capable, like that, then he is so called as a disqualification, guys. Okay, guys. And fourth one is the if that person is one who is having the office of profit. Guys, clear? Office of profit is also comes under the disqualification, guys. And the last one is if you see, if the member is disqualified by the act of any parliament under the disqualification, then he is disqualified. Means these are the provisions for a member to be disqualified from the house, guys. Clear? Oh, but we are not having the disqualification for about the detention, guys. Means with regard to the detention. That's why we have mentioned that in the article number 102 subclass 2, guys. 102 subclass 2. So in the subclass 2 it mentioned that a person shall be disqualified under the defection law provided under the schedule 10 of the constitution, guys. Guys, at the beginning of the constitution we have only 8 schedules, but after days passes we have added the schedule number 10, guys, through the 52nd constitutional amendment act in the year 1985, because to have the provisions regarding the disqualification through defection. Okay, so what does schedule 10 says? Schedule 10 says that, as I defined in the beginning, defection, guys, that is either if a person either voluntarily give up his membership or he is against the whip, that is he is disobeying. What does disobeying mean? That is abstaining or voting against the will of the whip member among the leadership is called as the anti-defection guys. So this provision has been mentioned in the 10th schedule, and the person who will decide is the presiding officer, that is the speaker guys in the parliament. Okay guys, so speaker will decide the whether to apply for the anti-defection or not. Okay, so if any member of the house gives that suggest the member to be disqualified, then the speaker will consider and speaker will process the things. Okay guys, so but this disqualification may be condensed guys, condensed. So disqualification may be condensed for a period of up to maximum 50 days. Okay guys, so if it is condensed on, then it will be invalid guys. So the disqualification will be invalid, but it will be done by the leadership of the party. If the leadership of the party condemns, then it will be not taken into consideration and the person will not be disqualified guys. So these provisions we have mentioned in the through 52nd Constitutional Amendment 1985 guys. Okay, so same provisions with respect to state legislature we are having through the 191 article number 191 subclass 2. So these provisions we are having at that place. Is clear? Okay, so what are the exceptions for this clause? So exceptions is that I said that through 52nd Constitutional Amendment 1985 it was amended. Okay, so why? Because it has amended means I said that in the year 1967 one MLA has changed the party for 3 times in a day. Okay, so to overcome this we have amended the constitution guys. Okay guys, so previous at the original constitution we are not having this provision, we are having the disqualification provision, but disqualification on the grounds of defection we are not having that provision guys. So to make that provision to have effective democracy of the political system, we have amended the constitution. So we have amended constitution means we have amended the articles and we have amended the schedules. So in the schedule number 10 we have added the anti-defection law. Right, it's clear? And in the same way in the articles 102 and the 191 we have added the subclass 2. Guys, clear? So but what is happening? So because of this not single person is jumping guys. Okay, so with this what happens, but previous we are having the provision of the split and the merger. So if a group of people want to split from its party, they can split, and again if the group of people want to merge into another party, they can merge. But as the days passes, the party is becoming democracy of the political system is damaging guys. So for that the previous so that is the 85th, so 52nd Constitutional Amendment we are having the provisions of the split and the merger. Okay, but as the days passes in the 91st Constitutional Amendment Act 2003, the split concept have been removed guys. Why? Because few people from the party are gathering and they are deciding to one thing, and they are saying that we want to be out of the party, as these provisions has been there in our 10th schedule, that is split. So to overcome this, that is like we can say we have proverb that is Ayaram and Gayaram. So he came and he went. So like that, to overcome this, in the 91st Constitutional Amendment Act 2003 we have removed the concept of the split. So what is the condition to be split? So 1/3 of the members should come out of the party if they want to join the another party, or if you want to keep another party guys. That is split concept. Concept is 1/3 members, whereas the merger, so this split concept has been removed through the 91st Constitutional Amendment Act 2003. Okay guys, but the merger concept has been kept. Okay, so what does merger concept means? So 2/3 of the members of the party should agree to merge into the another party guys. This is the merger concept. For example, the Congress of the Telangana decided to merge into the TRS. Example guys. Okay, so this is the split and the merger concept. Okay, but guys, in the 10th schedule we have some provisions like the presiding officer, that is the speaker, will decide whether this is to be under anti-defection or not guys. but we have the provisions that judicial review is not there for this, guys. So for this process, we are not having judicial review. Okay, guys, clear? But the Supreme Court in the Kohinotam case, that is in the year 1992, in the Kohinotam case, it clearly explained that this Supreme Court that judicial review, so anti-defection comes under the judicial review, guys. Judicial review means the Supreme Court can interfere in the defection and they will see, guys. Okay, that is judicial review. Clear, guys? So previous it is not a judicial. Previous it is not having judicial review and it is entirely with the presiding officer, that is the speaker, guys. Okay, but the Supreme Court strike that said it the people are voting by seeing the party and not by the people, individual people, guys. Why? Because some people will vote for the so and so candidate by seeing the candidate, some people vote, and by seeing the party, some people vote. That's why Supreme Court said that. So everything that is the anti-defection law comes under the judicial review, and from that onwards it is under the judicial review, guys. So we will see what are the things that Supreme Court said or explained as the days passes. In the Karnataka case, guys, so what happens in the Karnataka? So in the Karnataka, what happens is the JDU means some people have been came under defection by the speaker, guys. So speaker defected some people, guys. Okay, means because he is out of his, means because of the reasons that I explained, guys. Okay, but what's the presiding officer said? So he said that it is for the entire complete of its tenure. That is, so the tenure of those MLAs is from the 2018 to 2023, guys. The speaker said that it is for the disqualification for the entire period, and the speaker also said that the High Court will not be, say High Courts, sorry. So these people are not be again contesting the bypolls, guys. Okay, so on that case, the Supreme Court has said that it is the, so just the Supreme Court can say whether he is disqualified or not. But the period of disqualification and whether they can contest in the bypolls is not the jurisdiction of this presiding officer, guys. Okay, so these are the judgments that given by Supreme Court. So Supreme Court gets said that the one who are disqualified under the defection will contest into the bypolls. Okay, and again their tenure will not be reduced, and after that they can take the office of the members. Okay, so they can those members can take part in the public offices also, guys. So this is the judgment of the Supreme Court, and the Supreme Court has made these provisions to the Parliament also, guys. Okay, guys, this is about the anti-defection law, guys. And after that we can see that right now the Rajasthan, that is the issue of the things that is in the Congress party, we have bifurcation part and those things are going on. So in line of this, we have came with this provisions. Guys, what are the benefits? What are the disadvantages? What are the advantages? What are the reforms, guys? So the reforms, the first and foremost reform is the disqualification provision should be changed from the speaker to the governor at the state level and the president at the central level, guys. Okay, guys, such that they will be pure, democracy means it will be with a higher authority such that the decision will be taken properly, guys. So this is the one reform, guys. Okay, and the political parties should select the members carefully. Okay, guys, and there should be such provisions such that they won't move from one party to another party for a period of years. Like that, we should come with such provisions, guys. But what are the advantages, guys? So a horse trading in the politics can be rectified, guys. Okay, so and the decision can be taken properly. So political democracy will be established, strengthened. Okay, guys. So as the Gandhiji said, guys, politics is an sin without morality. Politics is an sin without morality, guys. So morals should be established in our members. Okay, so guys, but this anti-defection law can be seen with the three members, with the three types of systems, guys. Means the three types of systems is, guys, in the parliament or in the legislature, we will be having three types of persons. That is the one who is elected as a party member, who is the independent member, and who is the nominated member, guys. So we have different provisions for these three people, guys. So the first and foremost I said is the elected member, means party member. So party member will be disqualified under the anti-defection law. First one is if he voluntarily gives up his membership. Second one, he is against the whip, that is the directions of the leadership of the party, that is if he is abstaining or voting against, guys. Okay. On third point is the if he joins any party, guys. In these three conditions, the person is qualified, is treated as disqualified under anti-defection, guys. Guys, clear? After that we have independent party. If independent party joins any political party after he got elected, then he is disqualified as under anti-defection law, guys. Clear? So and after that, that is I said the third one is the nominated party. A nominated member can join any political party within 6 months, guys. Okay, within 6 months he can join any political party. So, but after that he can't join any political party, guys. So 6 months provision has been made in the 10th schedule, guys. Okay, this is about the three type of provisions, guys. Guys, in the first at the starting I said that to the one or second article and clause said there are five things on which the disqualification will be done, guys. So in that I said that the first and foremost is the if you voluntarily gives up. So that is not the correct statement, guys. That is the about the if you voluntarily give up the citizenship, guys. If you not voluntarily gives up the membership of the party, no. So if you voluntarily gives up the citizenship of India, or means that is if you lose the citizenship of India, or if you voluntarily acquire the citizenship of the foreign country, then he is treated as a disqualification. And the second one is the unsound mind. Third one is the discharged insolvent, guys. Okay, and the fourth one we are having so these are three, and the fourth one we are having the if it is disqualified under the Parliament Act. Okay, guys, and the last one is if it is disqualified under the Office of Profit, guys. So these are the 5 steps which we are having in the original constitution, guys. But right now we have discussed about the anti-defection, that is under the schedule number 10, guys. So thank you one and all, guys. Okay.